Good morning and welcome. It's nice to have you back. Our first webinar for 2021 in this particular platform. I am Jody van Wyk. I'm the Executive Manager for the South African Board for Sheriffs. And we really want to say thank you for taking the time to engage today. So what is today's engagement about? We have a platform that's been asked for in one of our consultative forums to engage with the CCMA. And this is to look at more specifically the execution of enforcement awards by sheriffs. Now, it's not limited to this area of expertise, but you will see and hear through the engagements how things go. So we are really glad that you could join us this morning. And I wish to introduce to you the moderator. All of us know him, Mr. Alan Murigan. He will be taking us through today's course. And I think what's important, and he would probably emphasize this as well, is that the whole purpose of today's engagement is really to engage and to ask questions and to ask things in clarity. And the purpose behind this is so that you can walk away feeling that there was a value add in terms of today's session. And your contribution is really valued because when you are asking us questions, we are then understanding what the concerns, what the challenges are on the ground. And this is the platform to do it. So please, please, please engage. There is a chat room, a Q&A room, where you can ask your questions, and these will be asked through the moderator throughout the course of today's session. I want to say a very special welcome to all of the board members. They may joke and say they are the outgoing board members, but they are still our board members. So welcome to all the board members and the chairperson today. And then a special welcome to the SANAPS chairperson, Ms. June Thomas, and the SAS president, Pietro Ruot, as well as the provincial senior commissioners and their staff who have taken the time to be here today. So without any further ado, please sit back, grab a cup of coffee if you don't already have one, and enjoy the engagement today. Thank you so much.
Good morning, ladies and gentlemen. Good morning to the chairperson of the South African Board for Sheriffs, Mrs. Charmaine Mabuza, the executive manager of the South African Board for Sheriffs, Jody van Wyk, Mr. Polisi Manshula, Senior Commissioner of the CCMA, Pietro Ruot, the President of SAS, June Thomas, the Chairperson of SANAPS, all senior and provincial commissioners, their team leaders, their staff of the CCMA, sheriffs, deputy sheriffs, administrative staff, good morning and welcome to this workshop on the execution of enforcement awards. Colleagues, the board views this workshop as a very important step to building a better relationship between the CCMA and the sheriff's profession, so that ultimately the litigants benefit from our services. I wish to very quickly outline the program of the day so that we have an organized approach to this workshop. Colleagues, we have presentations by the CCMA. Obviously, the engagement, as our executive manager pointed out early on, the engagement at the consultative forum, which is a forum established by the South African Board for Sheriffs for daily communication with the sheriff's profession on the ground. Through this forum, the sheriff's profession has highlighted various concerns that they have in regards to the amendment of the Labour Court Act that resulted in the enforcement awards process. Similarly, the CCMA has approached the South African Board for Sheriffs and requested some intervention in regards to their concerns relating to the execution of the enforcement awards. Thus, we have this workshop, colleagues. We're going to see a presentation by the CCMA, by Mr. Manshula, and on behalf of the profession, on behalf of SAS, we have Mr. Andy Adimulam, who will present the process of execution. Thereafter, we will give the opportunity to the panelists appointed by or selected by the both organizations and by CCMA to ask and answer questions related to our concerns. Participants that linked to this workshop are most welcome to post your questions on the chat line by the Q&A process, and I will ensure that these questions are posed to the panelists. Colleagues, I'm sure looking at the presentation by SAS and SANAPS and the CCMA, we have a lot of discussion to go through. So your questions, if not asked directly as per your name, might not mean that your concern is not posed, but it might mean that one of your representatives have asked that question and I have obviously addressed the concern. Without further ado, I'm going to call upon Mr. Manshula of the CCMA, Senior Commissioner, to do a presentation to us outlining the process that the CCMA follows in regards to their mandate in terms of the Labour Court Act, and obviously highlighting the concerns of the various CCMA officers all over the country in regards to the engagement with sheriffs on the ground. Mr. Manchula, over to you, sir.
Thank you, Mr. Murugan. Good morning once more to everyone that has joined our webinar today. We, as a CCMA, appreciate the opportunity to engage, as you've indicated, Mr. Murugan, with the profession. This is for the benefit of the users that we are all there to assist. My presentation is not going to be a very long presentation, but I hope that it will be a fruitful presentation in terms of addressing the concerns from a CCMA point of view and outlining what role we play in an enforcement process. And just briefly, the presentation will touch on the role of the CCMA, challenges that we encounter in the enforcement of arbitration awards, interpleader proceedings, the management and processing of sheriff's accounts, and our suggested areas of improvement. We see this relationship as an ongoing relationship where there are some areas like in any relationship of concern, and those areas need the parties that are involved in the relationship to work on those to try and improve. All right, what is the role of the CCMA, one may ask? We offer assistance in terms of Section 115 of the Labour Relations Act. Mostly our assistance that we offer to our users is administrative in nature. We undertake to pay reasonable enforcement fees for employees earning below the threshold. Awards that are issued by bargaining councils, whether in the private or public sector, are excluded from the payment scheme. This is important because we have in the past received invoices in respect of awards that an employee would have been in the public service where there would have been no communication to the sheriff that the CCMA would be responsible for the costs. These applications, when they are received by the CCMA, are processed in terms of our standard operating procedure, which requires that an LRA Form 718, upon completion, be served on the employer party. Our role here is for those employees who earn below the threshold is we would serve this upon assisting them to complete it, assist in serving it on the employer. But those employees who earn above the threshold, they are responsible for their own service. And the LRA Form 718 is only processed after 14 days of receipt. This is crucial for us because it assists us to control the process. In what way? We've served the 718 on the employer on behalf of the employee, and that space, that 2 weeks period, assists in saying to the employer, comply with the award, or if there is any possible rescission application that you intend bringing, do so within that period when we would not have incurred costs. The CCMA has a duty to deal, this is crucial, with rescission applications at any stage when such have been received. Employees remain a party in the enforcement process, and the CCMA is a non-party. We are merely responsible for payment of enforcement fees for those employees that earn below the threshold, but we are not a party. An initial instruction that goes out to the sheriff with the initial documents, with the enforcement of awards document that are issued, would be to the sheriff, attach only And if the employee wishes to proceed, the CCMA will then engage the sheriff and say, let's now execute. This helps us because we have limited financial resources for this function of enforcement, and we are all aware that the state is struggling, and this is going to continue for the foreseeable future. So we have to save costs where possible. This is available on our website. This is our information sheet, which helps to guide anyone that goes onto our website, being it the employer or the employee, in terms of how the process works. I'm not going to take you through all the steps that are contained in this. Safe to say that this is on our website. Anyone that would like to interrogate the document, they are free to do so by accessing the CCMA website. Now, what challenges are we faced with as an organization in this process of enforcement? Employees earning below the threshold are in some instances being asked to pay deposits, and this is despite the CCMA having undertaken in writing to cover enforcement costs. We acknowledge as an organization that there was a challenge in respect of the processing of sheriff's invoices. However, since the latter part of 2018, there has been a huge improvement in this aspect. This has been because initially this process was a centralized process where all the invoices were going to our national office, and with limited human resources, this became a challenge in terms of the processing of these invoices. However, since this process was decentralized to our provinces, we are in control of the process. We know what is going on. So in this case, one is confident sitting here to say there is an improvement. We do not expect any communication that says pay a deposit employee because there is an outstanding or a long overdue account by the CCMA. We also, in some instances, encounter reluctance by some sheriffs to open accounts for the CCMA. And what we've done in this case is we've gone to the board where these have been brought to our attention as the national office. We've gone to the board and we've gone to the associations and say, we need your assistance here as partners. Here is a written undertaking from the CCMA that we are responsible for the account. Secondly, there has been an improvement on how these accounts are managed by the CCMA. So we are not expecting this to be happening at this stage, if I may put it that way. And in respect of CCMA opening accounts for the CCMA, we see ourselves as a single entity. And in this regard, a single account for the CCMA would suffice. This specifically applies to instances where you have sheriffs whose jurisdiction would be covering more than one area of demarcation, those that are in the borders of provinces. We would encounter problems in those instances. And ours is to say, let's perhaps look at this. It should not be a problem from our point of view as the organization. And some sheriffs still take it upon themselves to advise defaulting employers to apply for rescissions. Now, when you look at this, this is not necessarily a huge problem, but it becomes a problem when the process is then stopped because there is advice that has been given. The sheriff does not do what the sheriff ought to do. The failure to execute where there is no rescission application is, in our view as the organization, not the correct way to go. It is once the rescission application has been received that the CCMA will communicate to the sheriff and say, we are in receipt of a rescission application. Please hang on a second. Let's deal with the rescission application. We will then advise you of the outcome thereafter. There is also, in some cases, the acceptance of review applications as automatically staying enforcement processes. Now, this is a settled issue, colleagues, in that unless there is an application before the Labour Court to stay the enforcement process, a review application does not result in the automatic stay of an enforcement process. It is only an order of the court that would say to the sheriff, that would say to the CCMA, that would say to the employee, this process of enforcement is being stayed pending the outcome of the review application. We have also seen a gap. This gap relates to public awareness on how the whole enforcement process works and how long it takes. We are doing our bit as an organization in terms of explaining to employees, but it would assist if also from the sheriff's sides that this message could also be drummed up, if I may put it that way, on those that we serve, that look, this is the process, this is how long the process takes, and this is what will happen from here onwards, and we anticipate that by this stage, this is where we will be. This assists in limiting and or avoiding unnecessary complaints when people understand how long the process takes and how the process takes. And what we've also picked up is there is a lack of collaboration among crucial stakeholders in this whole process. I'll give an example. A sheriff goes and attaches, and upon attaching, upon going back for execution, we find that there is the employer has taken the goods away and they've been hidden. And if these are referred to SABS to say, this is a criminal offense, SABS, can you possibly assist in this regard? And our SABS, unfortunately, in most instances, they do not know what to do or where to start. And the same applies in terms of where there are applications that need to be made. The involvement of your legal aid SA will be crucial in these processes so that we limit complaints, we limit frustrations to those that need and require our services. We also see that there is a need for improved communication between the various sheriff's offices and our regional offices in terms of what is required at a certain stage, and also this from both parties, because we have also seen that as an organization, in some instances, there would be a failure to communicate clear instructions to the sheriff in terms of what needs to happen. And there would be disputes months down the line when we, for instance, receive an invoice with what we would consider a huge sum of money. And when it comes to the calculation of interest in respect of the arbitration awards, we as an organization, and this has been discussed with the board and the associations previously, I think in 2019 around June, that our view is let the sheriffs add the interests on the awards that they are enforcing. There is no need in this instance to say there should be a variation of the arbitration award in order to add the interest to the amount. Another problematic area, third-party claims, your interpleader applications. It's crucial to note, colleagues, that the CCMA lacks jurisdiction to deal with this. Recommendations had been made by the organization to the Department of Employment and Labor and the Judge President of the Labor Courts for legislative reform. However, at this stage, we still are at a stage where there is absolutely nothing as an organization that we can do. And in this regard, instructions do not come from the CCMA. And the CCMA, it is crucial to note that it does not pay for any interpleader proceedings that may be executed, even if an employee earns below the threshold. We do not issue instructions. This is the role of the employee. The employee may approach Legal Aid South Africa for assistance in this regard. However, what we have picked up is the following. With Legal Aid South Africa, their means test is very low, unfortunately, even lower than the 211 some odd thousand that we have as the CCMA, which puts most employees out of the assistance that they could be benefiting from an organization like Legal Aid South Africa. However, they are in a process of looking at their regulations, and we, in our last communication with them, were made to believe that these have been through the board, and they are with the Department of Justice and Constitutional Development. Now, what do we do as an organization when we are dealing with these interpleader proceedings? Our main concern here, as you would understand, is how do we minimize storage costs? And this is where we would then advise the employee to say, employee, to put it bluntly, good people, you are on your own here. You may, however, approach Legal Aid South Africa, but we will not be paying for anything in this regard, but we will give you up to not more than 2 months to sort the issue out. Within that 2 months period, we will advise the sheriff to release the goods in order to minimize storage costs on the organization. The CCMA is aware that there is a potential abuse of this process by attorneys and employers. However, the issue remains out of the control of the CCMA. Now, moving on to the management of accounts. The CCMA pays for all reasonable costs in terms of the tariffs of fees, and these would include traveling costs, service of documents, attachment, execution, storage, advertising, sale. What is it that we expect from our partners, being the sheriffs in this case? We expect sheriffs to submit statements of accounts on a monthly basis to our regional and provincial offices. And upon payments being made, the expectation on us and what we should be doing is to send remittances to various sheriffs to say, this is the record, this is what has been paid. And upon those remittances being sent to sheriffs, and then accounts would be updated, statements would be updated by the sheriffs, and this would be to avoid duplication of invoices. Sheriffs are expected to submit invoices as and when services have been rendered. We have in our various provincial offices accounts administrators, and these are the first point of call when there is a query in terms of outstanding accounts. As I indicated earlier on, payments of sheriffs is a decentralized process, where there are challenges, where sheriffs are not winning in terms of their queries on outstanding accounts, provincial senior commissioners have the final say on payments of accounts. These are the heads of provinces. They are the ones who would make a call. They are the accounting officers, if I may put it that way, in all our 8 regional provinces. You would hear me saying 8 instead of 9. The Northern Cape, for those sheriffs who are based in the Northern Cape, the Northern Cape and the Free State is one province for purposes of our own demarcation, with the office of the Provincial Senior Commissioner being in Bloemfontein. And in this case, we encourage that you contact Provincial Senior Commissioners, and details had been shared with the board, SAS and SANAPS previously, and if there's a need for us to share these again, we will definitely do so. Now, what is it that we consider as areas of improvements in the service that we offer to our users? Advertising, for starters, we do not have resources on our part as an organization. As you would have noted in the previous slide, we pay for this, but it is preferable that sheriffs cover this and the CCMA pays. We also need assistance in terms of the problems that we encounter where the opening of accounts is still a problem with some sheriffs who are just not interested. And in this case, we call on the board and the associations to assist us because this would affect those employees who we consider vulnerable. There is a need also for improved communication between us as the organization and the sheriffs. Clear requests of instructions from sheriffs and quick responses needs to be given by the CCMA. Sheriffs are encouraged to recover their costs in instances where parties settle disputes, where the process of enforcement has been initiated. We, in that case, encourage sheriffs to say, good people, the process has already been initiated. My costs as a sheriff employer are this. Can you include my costs as reflected here? And then the CCMA should be the last resort in terms of payment of those accounts. Sheriffs also, we expect them to assist in explaining the process to employees where goods have been hidden after attachment. This is a process that I referred to earlier on, that you find employees going up and down between the offices of the sheriffs and the CCMA, and sometimes this leads to complaints internally at the CCMA and at the board, where sheriffs are accused of not willing to execute, where in this case, it is a matter of the employee not understanding the process. I mentioned earlier on that we need to forge stronger ties with your subs, for instance, who also need to understand that the above is a criminal offense and they should not be turning employees away, but they should be assisting. Applications to the Magistrates Court and to the Labour Court to attach banking accounts. In these cases, what we do is, as an organization, we would refer employees to Legal Aid SA, various pro bono offices around the country, the Legal Resources Center, various law clinics, and any other partners that we have, because we cannot. It is, I'm sure by now, well understood that the CCMA cannot on its own amend the writ of execution and add the banking details of an employer. We will only do so upon receipt of a court order. As I've already indicated, discussions are ongoing with Legal Aid SA. We are hoping that something positive will come out of this. This, Mr. Murugan and colleagues, brings us to the end of our presentation as an organization. Thank you so much.
Thank you, Mr. Manchule. There's a lot that you spoke about that obviously is a concern for sheriffs as well. But we will get to answering some of your concerns in a few minutes. But before we do that, we're going to ask the profession via Mr. Andy Adimulam, who is a registered assessor and facilitator with the South African Board for Sheriffs, and who does most of our facilitation on behalf of the profession, one of our assessors and facilitators. Mr. Adimulam will present to the CCMA and to the profession the process that is followed by the sheriff as soon as he is in possession of the enforcement award.
A very good morning to one and all. My name is Andy Adimulam. I'm the Sheriff for Johannesburg West and also the Deputy Chairperson of SAS, which is one of the organizations that represents one of the organizations in the profession. This morning, I'm going to take you through to the movable property, the process and procedure that is followed in every sheriff's offices, almost in all provinces. The second part being the sale and execution. And obviously, we follow Rule 41, that's in terms of the Magistrates Court Act, whereby the enforcement awards are also being used and the same process will apply. So this morning, I'll talk to you about when a process is brought into a sheriff's office. So obviously, once the document has been issued and sent to a sheriff's offices, the document is then registered on a computer system and then allocated to a deputy or a sheriff. There's some sheriff's offices that have deputies that are assigned to specific areas. And there are sheriffs that, because of a small office, will obviously execute the document himself or herself. After an attachment is made, a return is then processed and filed, and valuation of the property that has been attached is completed by the deputy. The original enforcement award is therefore in the file, and the notice of attachment is filed, and the file is opened, and the file is kept with the sheriff for further instructions from the CCMA via the applicant. Thereafter, we forward a copy and a notice of attachment to the attorney. So in this process, the Magistrates Court, obviously most of the time, instructions come from an attorney. So we need some clarity as to who is the instructing party when it comes in with regards to the CCMA enforcement awards. Should an attachment be made, we will then request for a sale date, and I'll take you through the various categories in terms of a sale date in the next one. Usually there's an attachment that is made. The value is either below 5,000 Rand or the value is above 5,000 Rand. One needs to understand when a deputy sheriff or a sheriff enters a property, he has to first identify himself and obviously ask if the defendant is present. And in terms of the rules, the defendant needs to point out his assets, or the deputy or the sheriff asks for them to demand payment. And if he can pay, then obviously the costs are calculated and he pays together with the sheriff's costs. If he doesn't point out assets, the deputy sheriff will then, or the sheriff will ask the defendant to point out assets. Then the deputy sheriff or sheriff will attach assets and therefore put a valuation to it. If the value is below 5,000 Rand, then the sheriff allocates a sale date 15 days after the date of attachment, and therefore he'll inform the attorney of the date, time, and place of sale. Yet again, here we are saying attorney because most of the time the attorneys are the instructing parties in the Magistrates Court writ, but in the enforcement award, obviously that will come from the CCMA. Then we inform the attorneys to forward the sales notice not less than 10 days before the sale to the sheriff, so the sheriff can affix to the notice board and the sheriff's offices. So where the value is below 5,000 Rand, that procedure is followed. If the value is above 5,000 Rand, then the sheriff allocates a sale date 15 days after the date of attachment. It then informs of the date and time and place of the sale. That's in terms of the Rule 41(8)(b). He then informs the attorney to forward a sales notice not less than 10 days before the sale to the sheriff, so you can affix the notice board at the court and the sheriff's offices. Now you will see there's a difference between the value of below 5,000 and a value above 5,000. And this is where the advertising costs or the advertising differs. What do we mean by a sale without advertising? Like we saw in the previous slide, if it's a sale where goods were attached that is below 5,000 Rand. We will then request indemnity in terms of Rule 38, and there's no need for advertising. I saw that Mr. Manchula did advise that assistance is required when it comes to advertising. The sheriffs, most of the sheriffs for enforcement awards will draw up a sales notice. If it's not for advertising, obviously we'll follow the rule to affix it to the court notice board and at their offices, and obviously proceed with the sale. Now, a sale with advertising, it means where the goods that were attached exceeds the threshold of 5,000 Rand. And therefore, the sale needs to be advertised in the local newspaper, circulating within the jurisdiction of where the defendant's property is. So we request for them to advertise not less than 10 days prior to the sale date in a local newspaper, circulating in the jurisdiction, Rule 41(8)(c), and then we request indemnity in terms of Rule 38. Now, one needs to understand when the advertising takes place, the cost for that advertising is roughly 2,800 Rand. And we obviously will bill the CCMA for it only if the defendant either runs or obviously absconded, but most of the time these costs are taken out from the sale. From the previous slide, once the indemnity is received, removal is done, and then obviously the goods in storage, that is for sale below 5,000 Rand. The one above 5,000 Rand, the sheriff will then receive the advert. He'll check if the advert is correct. And once the indemnity is received, the removal is done and goods in storage. Now, in modern times, most of the attorneys will now require the sheriffs, because of the storage costs and the removal costs, they always want that the goods be removed 5 days before the sale. And that can lead to also shooting yourself in the foot, because sometimes when the advert is placed, when the sheriff obviously or the deputy goes to remove, he finds that the goods are not on premises. The sheriff is required in terms of the CPA, FICA, to register all buyers, obtain ID, and copy of the utility not less than 3 months old. He has to pay the buyer registrar's fee, and obviously be handed a buyer's card. He will then be provided a receipt for his registration fee and obviously the goods. And we label all the goods that are in lots. We display the auction rules, and we read out the notice and the conditions of sale prior to the sale commencing, and we prepare the vendor roll of all sales. And thereafter, the funds are distributed to the trust creditors, here being the applicant on behalf of the CCMA. So the procedure for the CPA and FICA will apply in sales below 5,000 Rand and above 5,000 Rand. This procedure is obviously a procedure in the High Court as well, but the rules differ, and obviously there are certain changes in the High Court that is not applied in the Match Court. There's one slide, I think it's the one that we missed, is where the one for the interpleader, and that is where most of the delay comes. There's two things I'd like to talk about. The one where the attachment is made. When an attachment is made, we need to understand that the CCMA needs to be informed that the attachment is only valid for 4 months. So if instructions are going to come from the CCMA after the 4 months has gone, then that attachment is invalid. The second one I would like to address is the one for the interpleader. When an interpleader affidavit is filed with the sheriff's office, it becomes tedious because there's a problem with the issue of the attachment. Now, you need to understand that the attachment is only valid after the interpleader is issued and obviously the 4 months is extended. And that is where the delay comes. And we have noticed even in my office, that because of the jurisdiction and demarcations that have taken place, we find that applicants come to our offices where we do not cover those areas any longer. I suggest that the CCMA has a look at the South African Board for Sheriffs website, where it shows all the sheriff's offices on the database and the areas that they cover. I think that is end of my slideshow. Thank you, Mr. Murugan.
Thank you, Mr. Adimulam. Thanks for this very informative presentation. Trust that all parties understand now the process, especially to the CCMA commissioners and regional heads and staff that's present. This presentation can be made available to you by the South African Board for Sheriffs so that you can understand our process. Colleagues, as I mentioned earlier on, we will have an opportunity for Q&As. As you can see, the panelists for the Q&As is Mr. Manshule, and I'm sure he's got 2 or 3 other persons with him who will assist in answering questions on behalf of the profession. And then we have the profession representative, Mr. Ashraf Dawood, on behalf of SANAPS, and we have Mr. Ian Burton on behalf of SANAPS. We have Komotso Mpashlele on behalf of SAS, and Mr. Adimulam on behalf of SAS. We also have the chairperson of SANAPS, Mrs. June Thomas, and the SAS president, Mrs. Petra Root, to assist as well. I'm glad the heads of the organizations are present here today. I've identified a few concerns by the CCMA that needs assistance from the heads of the organization and the South African Board for Sheriffs, which I will highlight towards the end of our discussion. Mr. Manshule, I'm going to put you on the spot firstly. I see my Q&As are running wild here. I have questions raised by Mr. Ralph Gee, I'm sure he's a deputy sheriff, raising a few concerns. I'm just going to very quickly highlight a few so that you can respond to us. Mr. Gee says that a process should be put in place at the CCMA regarding part payments made to the plaintiff. What I'm understanding, what he's trying to say is that after the execution of the enforcement award, the defendants or the respondents would make part payment directly to the plaintiff, and the sheriff is not aware of this. So resulting in the sheriff incurring an attempted removal cost or attempted execution cost. It further goes on to say that once a part payment is made, there is no process at the CCMA to offset the part payment to the judgment debt. So in the magistrate's court process with attorneys, the attorney, once the plaintiff receives part payment, the attorney would obviously reissue his writ. Now, this process is not happening in the CCMA. Mr. Manshule, if you could respond to that, I'm going to ask you 2 more others so that you answer all 3 at the same time. One of the other concerns raised, as I said, Mr. Gee is a deputy sheriff and office manager, I'm sure, raises the issue of concerns by employers not receiving the initial notice of the arbitration. And this concern has been raised by the profession as well before. He says that in most cases, when the employer is approached with the enforcement award, the employer claims that he was not aware of any hearing that's taking place and resulting in now the execution of the award. So if you could respond to that. And the other issue that Mr. Gee has raised is the review application. I heard you, Mr. Manshule, in regards to the process the CCMA follow, but I would like some explanation. He says that once a review application is lodged, what is the decision by the CCMA? Does the review stop the execution? And he says 95% of these orders either go on review or get set aside due to the employer not receiving or not being notified of the arbitration process. Mr. Manshule, over to you.
I'll start with the last part. Review applications do not automatically stay the process of enforcement. That's 1. 2, where there is a rescission application, we are obliged as an organization to deal with that. What then happens in that regard is the following. We would advise the sheriff, or at least we must advise the sheriff, that we are in receipt of a rescission application. Please pause with the process pending the outcome of a rescission application that the employer has lodged. With regards to reviews, there must be an order of the Labour Court that stays the enforcement process in order for the enforcement process not to proceed pending the outcome of the review application. Second issue relates to notices to employers for arbitration dates, where these are the concerns. The employer would obviously come back to the CCMA and apply for a rescission, which we will deal with in terms of the process that I've already outlined. If a matter is taken on review for whatever reason, we require a court order staying the enforcement process. That is the position of the CCMA on the two. A review application has no automatic effect in terms of stopping the process. A review application, a rescission rather, puts a pause on the enforcement process pending a quick rescission process, which in most cases would cover the issue where an employer is alleging that they did not receive the notice of set down for the arbitration proceedings, and therefore they were not in willful default. When it comes to the issue of part payments being made by employers to satisfy the debt that is due, we can only go back and amend the writ if we are aware of this state of affairs. If this has not been brought to our attention, unfortunately, we would not be in a position to do anything and go back and amend the writ. The CCMA does go back and amend the writs where there would have been part payment that would have been made, but this needs to be communicated to the organization in order for the organization to deal with the process of saying part payment has been made in respect of the debt. The original amount that was due was 10 rands, 5 rands has been paid. What is due now is 5 rands. We would definitely deal with those. Thank you.
Thank you, Mr. Vanshule. I've got 3 more questions raised. Mr. Rantesh Rajkumar wants to know, I'm sure you answered this in your presentation, but I'm going to ask it for clarity. Will the CCMA pay the sheriff for the removal and storage cost of the goods? I'm presuming once the interpleader process is in process, received. Mrs. Annelie Rasmus raises this point in regards to your presentation earlier on, where you mentioned that the interest must be inserted by the sheriff or determined by the sheriff. She says that that is not in line with the Act, with the Magistrates Court Act, because firstly, the sheriffs are not allowed to amend a court document in the Magistrates Court. Any amendments to a Magistrates Court document must be done by the court and issued by the court. And obviously, in your case, the CCMA awards is your document. So sheriffs are not allowed to change any information on there. And obviously, we're not allowed to determine interest. So, you get courts and attorneys determining different rates of interest. So she says that cannot be possible for sheriffs to insert the interest. It must be the CCMA. And the I'm going to leave the third question because it's a rather big question. I see a few concerns have been raised regarding to that. I'll allow you to answer these two first.
Thank you. I will ask Marius to deal with the question of the interest, please. Marius?
Good morning to everybody. Yes, let's maybe quickly deal with the aspect of interest. I think the first distinction to be made is that the award of a CCMA is issued in terms of the Labour Relations Act and not in terms of the Magistrates Court Act. Furthermore, in terms of the Labour Relations Act, there is specific sections that deals with the aspect of interest, where it's very clear that the interest automatically accrues in as far as the order that is issued from the CCMA. So on that basis, from our side, we see no problem with regards to the process that we have, which is that the sheriff would actually just do the calculation on the interest as such. If you would also note that in terms of our awards, we don't specifically deal with the aspect of interest. And so that is because it's specifically stipulated in the legislation on how the aspect of interest is dealt with in terms of the Labour Relations Act. What we can do is we can circulate the specific extract. I think that might give some clarity with regards to how that specific aspect works from a CCMA perspective. Thank you very much.
Thank you. But I think it's important to understand that sheriffs follow a set process and is bound by the rules. He cannot determine the interest rates. Are we to assume that it would be the current interest rate that he would charge?
That is correct. Also, and what we can share with you is that the Labour Relations Act has got a specific section, memory serves at section 210, that says if there's any other legislation that's in contradiction of the Labour Relations Act, that the Labour Relations Act takes precedent. So therefore, even if there's something in the Magistrates Court Act that deals with a specific aspect, if the Labour Relations Act gives clarity on that for the purposes of CCMA awards and CCMA rulings, the practice as per the Labour Relations Act would then take precedent over any other piece of legislation. So yeah, that's maybe just to give some clarity in that regard.
I think while I'm with you online, if possible, that relevant section of the Act can be forwarded to the board after our discussion, so that would help the profession as well. Mr. Manshule, coming back to you, a few questions have been raised in regards to the interpleader process. Mr. Rishad Singh says that CCMA states that they do not handle interpleader matters. His concern is that in terms of the Magistrates Court Act, which we are enforcing in terms of the enforcement award, the Act makes provisions for the sheriff to inform the execution creditor of the interpleader claim. And the Act goes further on to say that should the execution creditor not respond to the interpleader affidavit or Rule 39 notice within 10 days, then the sheriff must automatically institute the interpleader process. He wants to know how would this work with the CCMA. A further question raised in regards to the interpleader, Mrs. June Thomas of the Sheriff Joburg South states that the interpleader process is posing a huge concern in regards to them executing the enforcement awards and satisfying the litigants, but goes further on to say that to her knowledge, the magistrate in the Joburg courts are willing to hear the CCMA interpleader summons, but they need engagement with the CCMA first. They need to clarify certain aspects of the CCMA. So it's from what I'm seeing, it's an invitation by the magistrates in the Joburg court to engage with the CCMA in order to set up a system in order to hear these interpleader summons. I'm going to leave you to answer those two there, Mr. Manshula, first.
Thank you, Mr. Murugan. Based on the presentation, the position of the CCMA is as follows. We do not get involved in interpleader applications or proceedings, and we do not pay for those. Ours would be to then say to the sheriff and to the employee, whilst this process is outstanding or needs to be resolved, we can only say to the sheriff, if goods are in storage, release those. The employee can come back to us once this issue has been resolved. And in this regard, I would also like Marius to perhaps add on this point.
Khaleesi, if I understood the question correctly, it's with regards to the interpleaders and maybe the approach from the CCMA in dealing with that. In as far as the magistrates from Johannesburg, of course, we will, set up an engagement with them to see how best we can try and assist the applicants in this regard. As Khaleesi in his presentation said earlier, I think we need to understand that the interpleader is a bit of a sticky issue, if I can use that term very loosely, purely because of the way that the amendment was drafted once they had given CCMA the authority to administratively assist in approximately 2015. So there are a range of issues. The solution for this whole scenario actually lies in a legislative change. Which unfortunately is beyond our realm. We can just keep on pushing in that specific area. But yeah, on the interpleaders, as I said, is what we can do to assist, we will. However, it must be understood it's within the confines and constraints of what the CCMA is able to do. Thank you very much.
Question for Mr. Manshula. Sheriff of Mafeking says the applicants cited on the awards with names and, for example, the name of the first applicant and 3 others. CCMA must provide detailed information in respect of who all the applicants are and who is entitled to what amounts of the award. Seems like clarity is needed when you citing the parties' names on the awards, stating that you must not say the first name and 3 others. You must specify the names of the applicants, which results in correct payments to these applicants. That's just one of the suggestions made by the Sheriff of Mafeking. This sheriff wants to know, when the CCMA counts days, do they count court days or do they include public holidays and weekends? Mr. Naidu, Sheriff of Mayerton, says that the advertising costs are very expensive, and in certain cases, when there are multiple enforcement awards for one office, the sheriff has to outlay between 6,000 to 10,000 rands for advertising costs. And some sheriffs cannot carry this cost and wait for the payment from the CCMA extensively. So something to think about there. The sheriff says, Annalie Erasmus says that unfortunately, the procedure followed by the sheriff in terms of executing writs should be the same as the procedure enforced in terms of the CCMA awards, as it is following the same Magistrates Court Act. I don't get what exactly she's trying to say, but she says the procedure should be both similar. Petrus says, one sheriff in our jurisdiction not willing to file the notice of auction and to advertise. According to them, we pay the role of an attorney and do not do that on our own. Well, the sheriff says it's not his duty to advertise the auction and obviously prepare the sales notices. It's something that we will address with him via your presentation. Mr. Manshula, your comments?
Yes, sir. The concerns around the citation and the correct amounts being attributed to the correct employees, that is noted. It is something that we keep an eye on, and our provincial senior commissioners are listening to this. We will further take it up and remind commissioners what the correct way of dealing with this. That point is taken. And on the issue of, we appreciate your commitment to take that issue up with the sheriff concerned. On the issue of, I'm not sure what other question that I might be leaving out here, sir. But the concerns that have been raised here are noted. We will definitely take these up internally, those that require us to deal with internally. Thank you.
For that. Sheriffs, Mrs. Teresa Withers of Cape Town would like clarity on the payment process. What she says is that she understands that the local CCMA office would obviously pay accounts for enforcement awards. How does it work when she receives an enforcement award from outside the jurisdiction and from another CCMA office? Who does she bill for the work done? Does she make an invoice out to the local CCMA office or the office or jurisdiction from where the document came? She needs clarity on that.
Here's what we can also do to assist in terms of facilitating and making easy for payments of accounts from outside the jurisdiction of the sheriffs. We will share the details of the various provincial offices of our accounts administrators, because those will have to go to those provinces or regional offices.
Thank you, sir. I'm going to stop here for now, and I'm going to give an opportunity to Mrs. Komotso Mpashlele to raise a few questions that the organization posed to this forum. I'm going to ask Komotso on the SAS presentation to go on the first three questions of their presentation. Starts with the point number 2, payment of sheriff's accounts, and point 3, interpreter proceedings, and it goes 3.2 up to the third party claim. You would note that some of these questions have been posed, but if SAS Komotso wants to elaborate.
Thank you, Alan. The first question, I'm going to ask 3 questions like Alan have said, and the first question relates to the sheriff's account. Mr. Manchula, I'd really like to acknowledge the fact that there have been quite a good improvement in the payment of sheriff's accounts, but we also get reports from our members of outstanding current and historic accounts. Now, the challenge is when we knock on the sheriff's doors and say, can you open accounts for the CCMA? Can you consider paying for this and then for various processes and then claiming money thereafter? It becomes very difficult where sheriffs are sitting with long outstanding accounts. So my question would be, what is the plan around that? Clearing all outstanding accounts? That would be the first question. And with regard to the interpreter proceedings, we know the challenges that interpreter proceedings are posing. They've been, some of the questions have been asked and some of the concerns have been covered in the presentation. I would not elaborate much on that, except that the applicant is really disadvantaged when the process is aborted. Now, while the CCMA and the Department of Justice and the board are in discussions on this matter, do we really just abandon the process? What is the way forward, and what do we do in the meantime? You mentioned earlier on in the Q&A session or in the presentation that once an interpleader application is lodged, it suspends the process. We have to remove if the goods have been removed into storage, that have to be released. And my issue here is because in most cases, when a certain aspect of a process gets aborted, it doesn't happen, we quickly report it to the board for sheriffs. Is there a possibility that there can be official communication by the CCMA to the profession, that is the board for sheriffs, to actually indicate that when this process happens, this is what we expect sheriffs to do? And we hope that, you know, the matter will be resolved soon, because really the applicants are really disadvantaged in the process. And the next issue would be the process that's followed after receipt of a third-party claim. We've been informed by the CCMA that the CCMA has no mandate to issue instructions on interpleader proceedings, and that has been dwelled on. this morning. Therefore, in an event that a claim is received and the complainant would like to pursue the matter on their own, the CCM doesn't pay, the CCM doesn't get involved. Now, the claimant has to go to court and defend themselves and stand up on their own against an employer who has, in most cases, legal representation. And really, the claimant is already prejudiced under those circumstances. I just want to know what is the position of the CCMA, because much as we are, the CCMA is there to support employees who are low-income earners, and we just leave them in the lurch like that. What is the position of a CCMA in that, or can that be looked at when the whole process of interpleader be looked at? Yeah, the last issue is in practice, it often happens that the attachment is uplifted and assets released upon the receipt of a third-party claim. Okay, as no instructions on issue of the issue of interpleader proceedings is forthcoming, either by the complainant or by the CCMA. The matter is installed, and the sheriff cannot proceed with the execution. Now, we identify this loophole in the system, and it is sometimes abused by the employers and the legal representation. Now, the question is, what is the position and what is it that CCMA can do about that? This is really challenges that disadvantages the process, the applicant, and eventually it just leaves the sheriff nowhere. In most instances, sheriffs incur a lot of storage costs, and that becomes very problematic to pay.
Thank you, Komotso. Mr. Manchula, you want to respond?
With regards to the issue of long outstanding accounts, you would recall, or let me put it this way, there was communication last year from the board to the Office of the National Senior Commissioner, where we were made aware of long outstanding accounts which needed to be cleared, and communication was then sent back to the board requesting that we be provided as the Office of the National Senior Commissioner with the details of these long outstanding accounts in order for us to make follow-ups. And I would still call on the profession together with the board that where there are these instances, please provide us with the details, then follow-ups can then be made with the relevant offices in respect of these long outstanding accounts, because as indicated earlier on, we really need your assistance. And in terms of improvement here, if there are to be improvements on both sides, once we pick on those up, we will indeed, as the national office, have a discussion with our provincial heads and say, this is what has been brought to our attention. Can we quickly attend to this and then respond? I will once more on the question of the interpleader and the way forward here, perhaps request Marius to deal with this one in terms of what the plan would be moving forward.
Thank you very much, Nkolisi, and thank you very much for the questions. I would just like to maybe quickly deal with the aspect of the official notification with regards to our stance to the interpleaders. Absolutely no problem. We will arrange that and circulate. If memory serves, we had, in fact, on previous occasions to the various associations made our position clear on this matter, but we will do so again. Absolutely no problem with regards to that. The second part, and maybe just I want to take a step back because there still seems to be a confusion about what the role is of the CCMA. So let me maybe put it in very simple terms, we do not represent the employee. We are not the attorney for the employee. Our obligation is to give administrative assistance. I think once you understand that context, you realize that there are certain things we can do and other things that's beyond the realm of what we can do. The second thing that must be remembered is that the CCMA is supplied with a certain amount of money from Department of Employment and Labor. And I'll put it out there, and maybe so this has been on various platforms. The amount of money that Department of Employment and Labor has given the CCMA for this specific function is in fact less than what we spend. So therefore, what we get in is less than what we eventually pay out. And we are currently subsidizing this area through our other parts of the organization. But the point, as I said, is that I want to clarify is the aspect of the role of the CCMA. We are assisting administratively. We are not the representative. I think that must be very clear, and that then starts, answering a lot of the other questions that flows. With regards to the interpleaders, I think we all share the pain with regards to the applicants of the consequence once those interpleaders are raised. Because from where we come from is we'd like these matters to be seen through to finality. That prohibits that from transpiring. So we share that concern in as far as the consequence of what happens there. From there, our engagements with the Legal Aid Board, we've even approached the what are they called? SASLAW, who does work pro bono, which is attorneys that deals with labor matters, to see in which ways they can assist applicants so we can potentially channel them in those directions. So it's not that we just throwing the people to the wolves, but we're trying to act within the confines of what we are required to do in terms of the LRA, and then at the same time trying to explore avenues in as far as how these applicants can be assisted. I'll once again reiterate to say that the key here is effectively legislative change. The pace of that, unfortunately, is not within our powers, nor within the realm of what we can dictate. We can purely request and consistently do so on a quarterly basis with the relevant powers that be to say, this remains a burning issue. Please, we need assistance. Here are our proposals on what the legislative could look like to sort of assist with this problem that we currently have. But in the end of the day, there's a bigger process and at a higher level than where we are at. So that's maybe just with regards to clarification. I think with regards to the other aspect with regards to the interpleaders, I think to a certain degree, maybe a communication from yourselves once the interpleaders are there to say this is what's been experienced. We can then from there liaise with the specific applicant and pose certain questions in as far as, can they dispute what the employer is saying? And I can share with you that my engagement with the Legal Aid Board, that has been the biggest problem, is that even if we arrange an attorney through the Legal Aid Board for the applicants aren't 9 times out of 10 in a position to dispute what is being said on the other side. So what we've found, and this is the feedback we've received from the Legal Aid Board, where they have tried to assist, they keep on running into that stumbling block, which then leads to a situation where, well, the goods are released in any event. So I think that's sort of the reality of what we faced. It is a bit of a vacuum. Where we can try and assist to the best of our ability, trying to bring in outside bodies like Legal Aid Board to try and help. But there's also a limitation, as I've already highlighted, on what we can do and what we can't do with regards to that specific aspect. So I think, that is as far as we can take it at this juncture. And I think yourselves are as frustrated as we are with regards to that scenario. But up until that legislative changes come through, it is a bit of a vacuum, which we can only, to the best of our ability, try and manage and help. But as I've indicated, there are limitations. Thank you very much.
Thank you, sir. I just want for the benefit of the profession to get clarity. So you're suggesting that once an interpleader affidavit is received by the respective sheriff, he can notify, or he must notify the local CCMA office, who will in turn give him or inform him not to proceed or proceed after consultation. Am I understanding correctly?
Correct, Alan. And I think it's part of what Nkolisi has indicated a bit earlier. It's that communication part. If there is, I think, one thing that we can improve on, it is that communication of where we're at. And with your permission, from our side, the one thing that we also don't get is once the sheriffs have actually gone through the execution, money has been paid out to the applicant, we basically not very often do we get returns from the sheriffs to indicate, well, listen, this process has now been finalized, unless we follow up or an applicant advises us. So maybe just from my side, and I'm abusing my airtime here, that would be something that would greatly assist us, because it will also help us to be able to monitor how many of these awards that we put through the system eventually get executed. Thank you very much.
Thank you, Mr. Manshule. I've got a few more suggestions and a question for you. Mr. Naidu of Sheriff Mayton says that he experiences problems with the CCMA not responding to the application for rescission when it is emailed to the CCMA. They do not acknowledge receipt of the application and do not provide further guidance or instructions to the sheriff. That's his query. Mr. Andrew Nkomisi, Sheriff Paul, states that there's a tendency by the applicant to very quickly amend service addresses of the respondents, which poses a problem for him when executing. In other words, the applicant realizes that the respondent has changed, the service changed his address of operating, and very quickly tries to amend the documents, which causes a problem for execution. Ben B, I don't know who is this person, but it says Ben B. If the defendant has proof of security bond payment, I'm presuming into the sheriff's trust account, is there still a need for the sheriff to proceed or wait for an order of court? I'm presuming for the rescission of application. It says that if the defendant has proof of security bond to their trust account and there is no labor court order to stay the process of enforcement, what do we do? So according to this sheriff, he says that once he's got payment in his trust account, does he still have to wait for the order to stop execution? Then another query by Sheriff Bloemfontein, where they say that they have Mandy has challenges with the Bloemfontein CCMA office not receiving or not accepting returns of services due to the COVID-19 pandemic. Wants to know when would this process stop and when can they further engage with the CCMA Bloemfontein to lodge CCMA returns or the returns of service. Mr. Manshule.
We have noted the concern on the failure to respond to communication relating to rescission applications. It is something that we will re-emphasize on the colleagues to deal with, and in this regard, I would go to an extent of inviting the sheriff where there is non-response in that regard. There is a channel through which this can be taken up with the head of the province, or an email could be sent to myself in this regard to say this is the issue that we are experiencing with regards to this particular office not responding to your rescission applications. We will definitely deal with it. Amendment of addresses by employees, we have noted the concern that has been raised by the sheriff in this regard. CCMA Bloemfontein, the concerns in terms of not accepting returns of service. This we will perhaps follow up with our colleagues in Bloemfontein. I'm not sure what could be happening here. Yes, there are measures that are in place to deal with the challenge that we are facing, but this does not affect delivery and service of documents to my knowledge. If the sheriff could perhaps provide me with your contact details, I will take the issue up with the provincial head and management in that office and ensure that something happens in this regard. Maras, if I may ask that you deal with the issue of the security of deposit versus the staying of proceedings, please.
Thank you very much, Mkhulisi. Yes, it's quite correct that with some amendments, the aspect of security has now been brought through. So in an essence, for those who haven't followed that specific saga, effectively, should somebody take an arbitration award on review, they can request that security be offered, or not can request, it is a requirement that security must be offered in as far as those awards are concerned. Should the security be placed with the Labour Court and proof thereof is supplied, my approach in as far as that is concerned is in those circumstances we will then not proceed. We won't necessarily wait for a specific order because the let's call it the payment or the what is due to the applicant has been secured at the Labour Court. However, let me hasten to add that we've had some discussions or documentation in the past being sent to us, and we need to be very careful with regards to the nature of the documents that we accept. Where people either go on word of mouth or people go with some written little document that now purports to be something from the Labour Court, and on that basis now tell the sheriff, listen, this is what has transpired. We would suggest that we only act with regards to proof from the actual Labour Court that security has been given. No other proof. Because sometimes what they do is they even supply you with a letter from their attorneys to say, well, we're in the process of sending it, or we have sent it. Well, the point is that the attorney may have sent such a letter, but that's not to say that had actually transpired. There would be confirmation from the Labour Court in that regard, where they say that security has now been received. So my suggestion would be is if you have that specific confirmation, then I'm comfortable to say in those circumstances, treat it, let's call it for lack of better terminology, equivalent of an order has now been issued because the security is there for the specific applicant, just with regards to that means. The one other thing, Khulisi, with the chair's permission and your permission, maybe just on the aspect with regards to sending information to a regional office, can we suggest that where practically possible, that information be sent in an electronic format? That would be the easiest way of dealing with that. The second aspect would be, as I've noted, a question that says, well, where do we send the information to? Once again, if you want to send information with regards to any of the writs that you're dealing with, you send it to the Provincial Senior Commissioner. We will again circulate the contact details in as far as email addresses, direct telephone numbers at the offices, as well as where the offices are situated, to the various associations and to the board for distribution then to the individual sheriffs. Thank you, Chair.
Mr. Khulisi, before I hand over to a representative of SABFS to ask a few questions on behalf of the organization raised by the members, there's one very important issue that has been raised by two sheriffs on this chat line, is in regards to the Rule 38 indemnity. They say that what guarantee do they have in regards to the Rule 38 indemnity should a challenge be posed in regards to the removal or execution of the sheriff's duties. Basically, what the sheriff is saying is that firstly, the sheriff's, the CCMA account with them is in arrears extensively. The plaintiff does not have means to satisfy the indemnity or the claim. Where does it leave the sheriff should a claim be brought against the sheriff whilst executing the enforcement award or removing and holding a sale and execution of the attached assets? How would that indemnity protect him or her? And then I've got Mr. Klaas Volker, who says that most of the problems experienced in his jurisdiction relates to the applicant misunderstanding the process between the CCMA and the sheriff's executing his duties. It's something that I think most of us have raised in this platform and externally as well. That's something that we obviously will leave to communication and effective communication, which you raised. I'm not going to ask you to answer that again. I just wanted to raise it here. I would like for you to respond to the indemnity issue, Mr. Manshule.
Thank you, sir. Once again, I will ask the NSC to deal with the issue of how the sheriff is protected when it comes to the issue of the indemnity. Maras, over to you.
Thanks, Mkulisi. I think let's maybe take a step back. If I understand the question correct, the basis for the concern relates to sheriffs that indicate that they haven't been paid. Therefore, they've got accounts, and therefore their worry is that even though we give the Rule 38 guarantee or indemnity, that we may not honor that. Now, I think the short answer is that when we give the guarantee, we will honor obligations where the sheriff acts within the scope of reasonableness. And I'll once again, highlight that specific part, where you act within reason. And I'll use a very simple example, and I nearly want to say it comes from personal experience, where sheriffs have actually go to a house, break the front door down, go inside because they assume somebody's living there, then just not even leave a notice, but they're at the wrong house. They got the address wrong, then leave the premises. And the owners of the premises then is informed by neighbors that, well, we've seen that and it's a sheriff that went through it. Now, in cases like that, then of course, if the sheriff acted negligently or outside of the scope of the instruction, the indemnity, of course, won't count. If you act within the scope of the instruction, then of course we will pay. We've always said that we're willing to pay, and once again I'll reiterate what Mkulisi has indicated. If there is anybody that's got a long outstanding account, please bring it to our attention. We've got no intention of not paying any sheriff. There's no there's no benefit for us not to pay, because we've got a relationship and a working relationship with yourselves. We want you guys to be happy. That's the key. Because if you're not happy, eventually it will surface in the service that's delivered, and us not having a good relationship then has an impact on social justice and people not getting the service that they require. So please, once again, if there is any outstanding areas of invoices, let us know. If you did not come right with the Provincial Senior Commissioner, we will deal with it. We will ensure that payment transpires. Maybe just the other thing I want to highlight, and I've noted that from some of the questions and hasn't come through yet, and that was the issue. We sometimes use tow trucks, or we sometimes use locksmith, and then we get queried by the CCMA when we basically put in a certain amount. Please understand that you will be questioned by the Provincial Senior Commissioner. For example, and I'll use one that I got, where a sheriff said they got a locksmith out and the bill was 2,000 Rand. When we analyzed that, we then realized, but the bill for the CCMA wasn't 2,000 Rand. That locksmith was used in 4 different executions, of which 3 had nothing to do with the CCMA executions. And our actual bill was something like, was a ratio, I think, of 500 or 450 Rand eventually. So please understand that when the Provincial Senior Commissioner gets that, they are duty bound to clarify that what is in front of them and what they sign off for is correct. So they may ask you for the tow truck invoice. They may ask you for the locksmith invoice. And what they're busy with when they do that is due diligence, making sure that once the money is paid out, that it's correctly paid out. Because remember that the provincial senior that signs for it, if there are audit findings, will have to answer why they did not check and verify if they had concerns. So please don't see it as challenging the invoice as such. It's purely a verification, and that is a requirement in terms of, from our side, as far as expending money is concerned. Make sure that when you pay out, that it's the correct amount that's been paid out. But let me also hasten to add that we've had some wonderful interaction with sheriffs as well, where if an error has occurred, immediately they will let us know and say, listen, we overcharged you on this aspect, or invoice might have been duplicated. We're crediting your account for X, Y, and Z, and it works like clockwork. So I want to give credit to the sheriffs as well when it comes to invoices and those types of scenarios that have occurred, where a lot of them have done brilliant work, and immediately things are rectified, and we continue that good relationship. So yeah, that's maybe just with regards to paying. We are more than willing to pay. Secondly, invoices, please let us know if you've got a problem at the provincial level. As Mkulisi has indicated, you can then address it to himself, and we will engage the province to see what the blockage is and help to remove that blockage.
I'm now going to hand over to Mr. Ian Burton or Ashraf Dawood to go through a list of queries that they have raised so that they are given an opportunity to address some of these. Mr. Ian Burton or Ashraf, if you're online, you can come in.
I'm on. If it's okay, if I go ahead. Good morning, everybody. Thank you very much for this opportunity that we've got to attend this workshop. If I can, I just want to follow up on what Marius said earlier on regarding the interest being calculated. Sheriffs should note that the interest rate was, in terms of outstanding debts and payments on outstanding debts, was amended and gazetted during September last year by the Minister, Mr. Lamola. And if no interest is charged on or stipulated on a document where interest needs to be collected, that interest rate is charged at 7%, which is the current prime rate, plus 3.5%. So if a calculation is made by a sheriff in terms of an award where interest is stipulated but not indicated, the sheriff must charge that 10.5% in terms of the government gazette that was issued in September 2020. I just want to also just a little bit elaborate on the security. We are currently finding that in my office, and I'm going to talk about my office, I mentioned it in our questionnaire as well, that we are receiving indemnity or Rule 38 securities from the CCMA where the sheriff is indemnified for 5,000 Rand. Now, if I was a debtor or a respondent, if I need to sue somebody, I'm not going to sue you for 5,000 Rand. I'll start at 1 million because that'll be my beginning point. So the CCMA needs to understand why we ask for open security. It needs to be very clear because it's also a requirement by the companies that insure us. But also, as Marius had said, your security is, you can't act unlawfully and still expect to be covered by your security if you know that you are doing something wrong. And just another thing, a lot of points have been touched on by Mr. Manchula and Marius, and I appreciate that. So we're not going to go back to the accounts and the security bonds, but there are certain aspects that we need clarity on, especially when it comes to removal instructions and what the CCMA is prepared to pay. I'm currently, as I'm going to use my office again, I currently have a CCMA matter where we've been given removal instructions and the goods that were attached are heavy earth moving equipment because that's quite a big claim. It's a party plus 5 or 6 others. For those goods to be removed, the quote that we've received by by a company to remove those goods is close to 100,000 Rand. The applicants want us to proceed. Who do I take instruction with to spend that 100,000 Rand? Who's going to pay that 100,000 Rand into my trust account to secure something that I need to pay beforehand, before the goods even go into storage, because the contracting company is expecting upfront payment, which makes it very difficult for us because we're dealing with the emotional side of the applicants who want the goods removed and the goods sold. So we need to get clarity on who's going to give us authority to make use of, whether it's 10,000 or 100,000 Rands worth of contractors to adhere to the award. And then one of the other questions, I'm not going to reinvent the wheel in terms of the interpleaders. A lot of questions have been asked, a lot of answers have been given. Again, in my jurisdiction, we have approached the chief magistrate, the senior magistrate here at Palm Ridge. They have gone into an agreement with us where they open, let's call it a dummy file under a magistrate court case number, and the interpleaders are filed accordingly. Our concern is that now the applicants disappear and we can't proceed because we can't get hold of them. We need funds deposited into our trust so that we can proceed, and we can't get hold of them. Now the interpleader is not even issued, hence the attachment lapses, which they don't understand. And the same with this, referring them to legal aid. the time period between the interpleader being issued when legal aid says, yes, we will assist, is so long that the attachment has lapsed. Well, it lapsed 2 months ago. And the applicants cannot, now we need to go and reattach. And that's the other problem. We'll need instructions from the CCMA to reattach, and not from the client or the applicant, because the 4 months it's done. But those are a bit of just a few of the points that we would like to raise. There are some more, but I would just like to hear a response from anybody if there's anybody that can just follow up on that. Thank you.
I think once again, thank you very much for the questions. We've heard you with regards to the indemnity and the limitations with regards to that. What I'll undertake to do is have a relook at that specific issue, because from recollection, I think, that was a change that we brought about a year or two ago. So from my side, what we will do is have a relook at that situation and see whether or not we can't amend it. I hear you with regards to open indemnity. We'll have a chat, as I said, internally and see what we can do to assist in that regard. With regards to the aspect on the upliftment of goods where you would require payment in advance, I think the issue is not so much a willingness to assist, but whether or not in terms of the legislation that covers us as far as public finance is concerned, whether or not we can make those payments in advance to cover that scenario. So that to a larger degree is where the problem lies, rather than maybe a willingness to assist. So as with the aspect with regards to the indemnity and the amount, what we can do is have a look and have a discussion with our finance department, our chief financial officer, to see if there's a way that we can work around that. I may mention that, last time that I had a discussion with them, the answer was no, we can't. But what I've learned is nothing is lost by just posing the question again and see if there might have been some changes to see if we can accommodate for those scenarios. My suggestion would be, maybe just as an add-on to that, is once the sheriff gets to those amounts where you now see, but listen, we're talking 20, 30, 40, 100,000 Rand. A suggestion would be as an engagement with the relevant PSC to bring it to their attention. The PSC may then want to engage us, but just so that we're all on the same page once that happens, so that should the invoice eventually come through from yourselves, that we don't have a scenario to say, but good grief, if you told me of X of Y, we could have thought about A or B to try and deal with the scenario, but now we're just sitting with that specific invoice. So I think that area is a communication aspect that will be appreciated. And secondly, what we'll undertake to do is revert back to our CFO to see what could be done around that specific aspect. The last area, I think that was, I think that those are the two main issues that was raised in as far as the payments, the aspect with regards to the indemnity forms. Thank you very much, Chair.
Okay, Ashraf, if you want to continue asking further questions on behalf of SABFS.
Thank you so much. Mine is not so much questions, it's more of an observation and perhaps a suggestion in terms of managing the employees' expectations. We have many of them that come to the offices with the enforcement awards, and many of them are under the impression that they're there to collect the money from the sheriff's office. So my suggestion, if possible, is that if we could inform the applicants as to exactly what to expect at the sheriff's office, it would make, I think, many tasks easier. We would be able to manage the expectation, because we've got people coming in, and I've actually heard this myself, where they say we're here to collect our money. So, that would assist a great deal if we could manage that expectation. And then the other questions that I have is from a specific one from one of our members. It has to do indirectly with an interpleader, but this is the situation he's sitting in right now. He was given a document where a trade union assisted the employee from bringing an application. The money was paid over to the sheriff. Now here's the situation. The trade union wants the money, and so does the applicant. Now, both of them are claiming the money. Now, usually we would interplead in a matter like this. So we understand that the CCMA doesn't get involved in the interpleaders, that the applicant has to pay for the interpleader. But here's a more difficult, here's another complication. We've been informed by the Pretoria Magistrates Court that they are not prepared to hear any interpleaders regarding the CCMA. So yes, the applicant will pay for the interpleader. The question is, where will the interpleader be heard, and how can we resolve this issue? And then I think my colleague did ask the other questions regarding the Rule 38, where we require unlimited. It was answered. Another question here is, who is the instructor? Does the CCMA give the instruction, or is the applicant bringing the document in giving instructions? There are many, many occasions where the person bringing in the document would ask for unrealistic, give unrealistic instructions that goes way beyond the rules. And if sometimes many of our colleagues have been reported to the board because they refuse to carry out those instructions become exorbitant in cost and sometimes are beyond the rules. So again, it comes to the point where I think the applicants or these people bringing in the document should be informed exactly as to what to expect from the sheriff, and to give clear direction as to who is going to give instructions. Is the CCMA giving the instruction, or is the applicant bringing the instructions? Thank you very much.
Thank you, Ashraf. Mr. Manchula, you want to respond?
Thank you, sir. Just to go back to a question that was asked earlier on in terms of what the CCMA uses in terms of calculation of days. In this regard, the Interpretation Act is used in terms of the reckoning of the number of days. It's one question that I left out, and one of my colleagues kindly reminded me of this. Thank you. Management of expectations from employees, we note this. We will endeavor to try and deal with it. It is a challenge. It is a challenge that requires both the CCMA and the profession actually to deal with and explain to this. As I mentioned earlier on, some of the complaints would come from these that Mr. Dawood has termed as unrealistic expectations. It's all about not understanding how the process works. It is all about not understanding how long the process works and expecting, as you rightfully put it, that I walk into the sheriff's office, pay me my money, and then I walk away. And we have a duty as the profession and the organization to deal with that in terms of educating the public. The second one, trade union employee who to pay the money to. For me, there is a simple answer. The employee has been paying the trade union subscription fees. Is the union operating in the same fashion as an attorney? Does the union have a trust account where the money would be paid to? I would be wary as the sheriff to pay the money to the trade union, lest I attract problems down the line. Who is the party that is being assisted in this regard? Who should be benefiting from the award? Is the award in favor of the union? Is the award in favor of the employee? If the award is in favor of the employee who was represented by the trade union, I would say tread very carefully in that regard. The issue of the Pretoria Magistrates Court saying we're not prepared to hear interpleaders in relation to CCMA matters. We can see where the problem lies. As Marius has already indicated, where does the answer lie here? The answer lies in the amendment of legislation. Their approach is completely different to the approach that Johannesburg has adopted, as we have been informed that Johannesburg says, let's engage on this issue. We are willing to assist. And whereas in this regard, the approach is, no, we're not. It also goes back to the issue that I mentioned earlier on. We have all these role players and stakeholders, if I may put it that way, where we are working in silos. What needs to be understood here is in terms of the role that the CCMA plays as a creature of statehood, it is a very limited role. We offer administrative assistance. We undertake to pay these fees on behalf of employees that earn below the threshold. Over and above that, it then becomes a challenge. Who is the instructor? The CCMA is not a party in the enforcement process. Our interest is in respect of those employees that earn below the threshold where we are responsible for payment of the cost. The employee remains the instructing party. It is, however, a bit of a problematic relationship in that instructions would come from the employee who is expecting A, B, C, and D from the process. However, the CCMA, with the limited funds that it has to somehow interfere and intervene in the process in terms of saying to the sheriff, this is what can happen now and this is what cannot happen now. Thank you.
From my side, if I can make a suggestion, why would the CCMA not consider the sheriffs to serve in terms of the rules? As I went and perused the Rule 5 in terms of services. Why can the sheriff not get involved in services of the pre-award documents in an attempt to make sure that the applicants have cited the right address and also that the respondents receive those documents? Will that not be a cost-saving method when it comes to removals, storage, issues of interpleaders? Because then by the time the sheriff gets the award, the respondent cannot turn around and say, I did not receive it, or it was never given to me, or I'm not aware of this claim. Would that not be a cost-effective as well as a time-saving method of overcoming a lot of these problems that we are currently experiencing? Just a question from us. Thank you very much.
Thank you, Mr. Manshule.
Thanks, Mr. Patton and Mr. Murugan. This is not the first time this question is coming up. NSC, can I request that you deal with this one? Thank you.
Thank you, Mkhulisi, Chair. Once again, thank you for the question. Quite correctly, as Mkhulisi has indicated, it's not the first time that this proposal has been made. But let me maybe quickly indicate to the sheriffs what is the process that we follow in as far as service is concerned. The first is that our services is either via fax, email, as well as, it could be postage, a variety of ways. Then there is also an automatic SMS notification that is sent at the same time when the fax, the email, and the rest is sent. That self-same SMS is sent 2 days prior to the actual hearing to the specific respondent. Once the award is issued, as part of the certification process, if the applicant comes back and let's assume the respondent did not attend, we once again verify the details of the respondent, which entails a phone call to the respondent to check on details. Are they planning to lodge a rescission? Why weren't they actually at the hearing? Maybe they were sick and they haven't notified us or anything like that. So by the time we have issued the certified award, there would have been at least 6 checks on the details with regards to the specific employer. So from my side, I'm not saying that, it's impossible that you have a scenario where an employer might have changed address or something like that has happened. But I think we need to be wary where employers indicate, I've never heard anything about this award, when we as a fact know from the CCMA side that before we issue a certified award, there would have been up to 6 checks on the contact details with regards to that specific employer. So yeah, it is from our side. Maybe just the honest question or the honest answer is to email a award and a notice, as well as to telephonically verify vis-a-vis paying a sheriff's fees to go and serve that notice. There would be a vast difference. The consequence of that is, should we go with the other option, is under these circumstances, is that we will run into further financial constraints. So if I had to be honest, that is one of the key things, that would hinder us from utilizing any other method. Also, on top of that, what we've done is we've enhanced our control mechanisms in as far as that specific aspect is concerned. And once again, I think police has also raised it to say that let's be careful when an employer purely says, but I never received it. Because as I said, as by that stage, there would have been at least 6 checks with regard to those details, and so forth and so forth. So yeah, Mr. Burton, yes, first prize. I think coming from a legal background myself would be as if we get that return from the sheriff, we feel far more comfortable. But the reality for us is, one is a cost issue, and the second aspect is we've got internal control systems, which we feel is reasonably adequate at this stage. Thank you.
Thank you, sir. Thank you very much, Mr. Burton. Thank you very much. Before I move on to questions from SAS, I just want to go online here. There's a few questions or suggestions to Mr. Manchule. And Sheriff Mrs. Erasmus says that once she holds a sale in execution and completes the distribution account, and in most cases collects the amount due to the CCMA from the respondents, upon presentation of a distribution account to the CCMA together with a month-end statement, CCMA does not deduct that amount that she already collected from the respondent before making payment to her, which results in double payments to the sheriff. So she calls on the CCMA to look into this because she does not think the reconciliation is being done correctly. Obviously, this would save the CCMA money if you are perusing the distribution accounts, and obviously, as indicated in the distribution account, that the sheriff has already been paid. That's something that she wants to bring to your attention. Mr. Henrik Tau has a problem with late payments from the CCMA, wherein he says that apart from not receiving payment from the CCMA, he has service providers that he needs to pay, and most importantly, he needs to pay the receiver of revenue. And he feels that it's becoming a problem for him in order to meet his obligations in terms of payment of his service providers and the receiver of revenue. CCA calls on CCMA to look into the matter of paying sheriff's fees timeously. Another question that was raised, which is important, I feel. Sheriff Bloemfontein 1 asks a question: does the commissioners at the CCMA have the power to instruct the sheriff to remove the attached goods immediately upon execution? Now, in the magistrate's court, the rules provide that if the sheriff or if the judgment creditor wants to remove goods immediately upon attachment, they would have to go through a process at the magistrate's court and get an order to direct or get the writ authorized for immediate removal. Does the CCMA have the power to do that? She further goes on to say, if that is the case, it would resolve the issue of goods disappearing at the time of removal or at the time of sale. The goods will immediately be stored at the sheriff's office. That's another question. Mr. Manchula, you want to respond?
Thank you, Mr. Murugan. We have noted the comment and suggestions on proper reconciliations and that we need to be vigilant when we are dealing with those distribution accounts, late payments from the CCMA, the effect on the obligations of the sheriffs. Once more, colleagues, where we are still experiencing the issue of late payments, we call upon the members of the profession to, one, communicate with the heads of provinces in respect of those late payments and long overdue accounts, and the national office as well, ourselves. We would also assist if this is brought to our attention in terms of liaising with the province and the sheriff in terms of rectifying whatever is the problem in respect of these outstanding accounts. It is an undesirable situation. We do not want in 2021 to be still dealing with the issue of long outstanding accounts and late payments. So please communicate with the provincial heads. We are willing to look into these together with the national office as well. I will then ask you, will note, Mr. Murugan, that in the workshop that we had, I think it was on the 5th of February, if memory serves me well, where this issue came up, our presentation was to the board and the associations. The position of the CCMA currently is we issue a communication that says attach. Thereafter, if the employee wishes to pursue the issue further, and then further communication would then be in respect of the removal. We note the issue of goods disappearing and that this would assist. However, from a cost point of view at the CCMA, it is with that in mind that we took this decision. And Maras, I don't know on this last issue whether you can perhaps add something to it. Thank you.
Maybe just with regards to the question of immediate removal and orders that magistrates can or cannot make, please note that the CCMA Commission will not have that authority. They are limited in as far as their orders are concerned in terms of the guidelines of the Labour Relations Act, and the mentioned order would not be one that they would be able to issue in terms of what their powers are. Thank you, Mr.
Thank you very much, colleagues. Okay, I'm going to ask Mr. Ian Burton, Ashraf, Komotso, and Andy to respond, because I'm assuming these questions are coming from the CCMA representatives. So if you could please respond. There is a question posed here where this person states that the sheriff executed the writ, the enforcement award, and subsequently got paid for his service by the respondent, but simultaneously charged the CCMA and also charged the plaintiff the fees. And CCMA has made payment to him, but the sheriff refuses to pay back the money to the applicant. That's one question posed. The other question posed is it possible to only remove when the auction date is available? In other words, Petrus states, is it possible to only remove when the auction date is available? The third question posed, is there a set amount for storage of goods? Those are three questions posed, I'm presuming, from representatives of the CCMA. Somebody wants to answer on behalf of the profession?
Thanks, Alan. I'm just going to, especially on the set storage charges, we need to realize that we also, as a sheriff, you rent a facility and you are charged per square meter. So it will differ from sheriff to sheriff because he has a lease contract in place of which a portion is probably store, or he rents a specific storage facility. And therefore, there will not be a fixed storage charge for items, because we are charged per square meter, and we accordingly will charge whoever goods we are storing per square meter. So I don't think, I would say there can't be a set fee for storage of goods.
Another question has been raised by Bongemusi, presuming on behalf of the CCMA. When a sheriff is unable to gain entry into the respondent's premises, some sheriffs stop the process and post the original enforcement document to the CCMA instead of advising the applicant. Is that your practice and procedure?
I will go back and answer the question on duplicate fees. All right, whereby the execution costs are collected with the payment of a judgment debt, and then the CCMA is also sort of billed for those costs. It is a wrong practice. The first prize for the sheriff is to recover the costs from the judge when the judgment debt is paid. And therefore, once that is done and the sheriff's fees are paid in full, there is really no need to claim that from the CCMA. I think that is just a correct practice. Okay, and removal only when the sale date is available. In terms of a rule, you remove and you keep the goods in storage, and thereafter you actually advise the applicant of the sale date. When, because they have to confirm when would it suit them best to sort of to have a sale in execution conducted. So you do not only have to remove when the sale date is applicable. However, in the presentation by Andy, he did mention the danger of only removing closer to the sale date, and that needs to be taken into account as well. For a lot of reasons, one being that the goods might have been removed. Okay. When a sheriff is unable to gain entry, and the sheriff has got permission by the applicant to use the services of a locksmith to open the premises and gain the entry and gain entry into the premises, the sheriff should actually be exercise that right to gain entry. However, one problem that is often experienced by the sheriffs is that once you've been given the permission to gain entry using the services of a locksmith, is that it only allows you to gain entry into the main premises and not at a gate, especially if it is the premises are within a complex. That permission doesn't actually allow you to open the main gate of a main premises. But yes, when you have that permission to use service of a locksmith, yes, the sheriff can go ahead and gain entry and inventories or whatever goods they may be found in the property. Thank you.
Thank you, Komotso. Andy, a question has been raised by the CCMA. They say in your presentation, you have mentioned that all actions occasioned by Rule 41.8 should be finalized within 4 months. Is this calendar days utilized to do the calculation? In other words, are you using calendar dates to do the calculation?
In terms of that, we use the court days. So it's Monday to Friday. So obviously it's 4 months. So it's calendar days that we will take into account.
When the sheriff is unable to gain entry into the respondent's premises, some sheriffs stop the process and post the original enforcement document to the CCMA instead of advising the applicant. Is that your practice?
No, surely it's not the practice. We will obviously record our attempts on the document. And should we have the telephone numbers of the applicant, we would usually call them and explain to them that this is a possibility, this is a problem we are having. And obviously they need to give us further instructions, and that's where it is. But we don't post back the document or return the document to the CCMA. That's not our practice.
Okay, thank you very much, Andy. Another question posed. If the sheriff executes and proceeds to sell, but the amount on the order is not met, who has the right to instruct the sheriff to make another attachment? I think this question is posed to Mr. Manshula. Thank you, Andy.
Who is the instructing party? It goes back to that the CCMA is not the instructing party. However, we do assist employees when they come back to us to say, look, after the initial sale, the whole amount that was due to me was not paid. I believe the employer now is in a position to satisfy the full debt. We do assist employees in that regard. In terms of instruction, the employee remains the instructing party. The CCMA would make a call in terms of the costs at that stage. Thank you.
Thank you, Mr. Manshula. We are aware that Rule 41 of the Magistrates Court Act does not make provision for the attachment of the respondent's bank account. When does Section 72 find application? And what is the time frame to make such an application?
I think it's very important that we understand that they need to issue a second document in terms of that Section 72, because it needs to become a garnish order in terms of the match court rules. It's a very good question. That can be done once the CCMA has received the return, or the applicant has received the return from the sheriff to state that there are no assets and they want to go after that account. That is something they will need to approach. I'm talking under correction now, they will have to approach the Labour Court directly, or even the CCMA for direction to the Labour Court to assist them in issuing a document like that. Because, as we all know, in terms of the we can't attach banking accounts in terms of the standard award.
I'm now going to give an opportunity for Andy and Komotso. Andy, if you want to come in to pose further questions on the SAS presentation. I know you didn't finish your questions. If there's anything that you want to raise in your SAS document that's not been addressed.
The one issue that that I'd just like to highlight as just a comment is that we often receive enforcement awards without copies for service. And when the sheriff's officers actually make and bill for those copies, it just raises a query with the CCMA. Please, the CCMA must be aware that once we do not receive copies for service, we will make copies and bill the CCMA with it. Secondly, I just want to go back to the issue of the historic accounts. Yes, I appreciate the CCMA is committing to settling those outstanding accounts. However, is it possible that the CCMA can actually say those long outstanding accounts so that we involve a national office, meaning that can we get information on all those outstanding accounts from members and just liaise directly with the national office for resolution? Because clearly members have gone through the provincial structures, they've had no luck, and that is why we are here. So we cannot just continue applying the same strategy that has not delivered on results. And one more issue is, again, on the management of expectations. And the point that I'd like to raise here is the issue of preparing of a notice of sale and advertisements. And this is a process that is very important to follow if the goods that are supposed to be sold in execution exceed 5,000 rands. The drafting and publishing of the notices, please note that it is not the responsibility of a sheriff. It is the responsibility of the applicant. We do, however, understand that there are instances where the sheriff's office need to assist the applicant, but it is not our responsibility. So if applicants come to our office and say, it shouldn't be like that. And as a follow-up on that one, it would actually help if the CCMA can just give applicants information sheet of what to expect, what the process entails, what the role of a sheriff is, and what the sheriff can or cannot do, and possible outcomes, i.e. there could be rescission application, there could be the review, and all other possibilities, so that the applicant doesn't come expecting to get money immediately from the sheriff. If we could just tie those issues and concerns, are up, and we give the proper information to the applicant before they come to the sheriff's office, that they know what to expect and what not to expect. That is very accurate. Thank you.
Thank you, ma'am. Andy, is there anything further from your side on behalf of SAS?
Yes, not really. Just one we have where there are complaints made to the South African Board for Sheriffs in regard to the sheriff not performing his duties or executing. We understand, and I think that the CCMA needs to be aware that the complaint obviously is recorded to the South African Board for Sheriffs against the sheriff. So it's not very healthy to have a complaint against your office. However, SAS recommends that before a complaint is lodged with the South African Board for Sheriffs, that the applicant arranges a meeting with the sheriff to discuss the problems he's facing with that office. And therefore, the sheriff will be able to respond as to what is taking place. And normally you will get the sheriff's responses will be that interpleaders, we can't attach bank accounts. So those are the responses you might get from the sheriff. And only if the applicant comes back to the CCMA and then says that, you know what, I've been to the sheriff's office and I've not gotten any response or positive response or any assistance from the sheriff, then a valid complaint is warranted. But until then, we urge that the CCMA inform the applicants that to make an appointment with the sheriff concerned. And on the other points, I hope Marius is listening. We don't want to put the notice of the first notice that had been served under the bus just yet. I think our president has got a suggestion or that we can put forward. So I will allow her that she would explain that process. In terms of the attachment of the bank accounts and the preparing of the sales notice, I see my colleague was absolutely correct. I did hear that Marius did say that they have legal aid attorneys, but also attorneys that will assist in pro bono work. I don't know whether this is possible, but if we could have a list of attorneys that are availing themselves to perform these duties, then maybe the application in terms of Section 72 and the drafting of the sales notice and obviously advertising will be minimal, and that task on the sheriff won't be so tedious. So maybe a suggestion or recommendation, if attorneys that are willing to assist in pro bono work, that they will be roped in order to assist the sheriffs, and mostly the applicants and the CCMA in this process. Thanks, Alan.
Thank you very much, Andy. Mr. Manchula, any comments from your side?
We have noted the suggestions, Mr. Murugan. I will once more on the issue of the long overdue accounts keep on referring to the correspondence with the associations and the board from the office of the NSC last year, where we requested these details, and it would assist us a great deal if those details could be provided. You have the email addresses of the provincial senior commissioners. You have my email address from the board as well. We would appreciate those details. Then follow-ups would be made. As for the other suggestions in terms of managing of expectations, we have taken note of that. We will do our part. It is, as indicated earlier on, a collective effort where also at the offices of the sheriffs, proper explanations to these applicants as well would also assist, and also in some instances just to pick up a phone call and say, this person is back again here, what exactly is happening? And on our side, it's something that we will look to improve on, because it's not really assisting when there are complaints when there should not be complaints. Thank you so much.
Thank you, Ms. Manchula. I want to give an opportunity to Tertia, if she's online, if there's anything she wants to raise on behalf of the CCMA. Tertia, is there anything that you want to raise?
No, I think everything has been addressed by Mfilisi, and RS has, provided sufficient answers. If we can just make sure that all the questions that our ESCs and RSCs posted on the question part that be responded to. But other than that, thank you very much, Alan. Nothing from my side.
Okay, thank you. There's one more question. Thank you, Tertia. Thank you very much. Laurie W. posed a question to the sheriff's profession. I'm just going to read it out. She says, if you have any information pamphlet that sets out the role of the sheriffs in the enforcement process or something similar that the CCMA can share with users, that would be appreciated. This would help with the issue of managing expectations. Laurie, to answer your question, the profession does not have pamphlets at the moment outlining the execution process and procedure, but each sheriff in his respective office would have a process or information process that he outlines to the applicant. As a member of the South African Board for Sheriffs, and especially the training chairperson of the board, I'm aware that the board is in the process of drawing up a pamphlet for the CCMA enforcement award process, and I'm sure the new board will be mandated to further engage this pamphlet development. I'm aware that the process is already underway in the board. So yeah, to answer that question. I've got one last one right at the bottom, Mr. Bongi Musi. He says that employees have approached CCMA complaining about the conduct of some sheriffs. Is it possible for sheriffs to provide employees with their contact details? Should the applicant CCMA wish to obtain clarity in regards to complaints before escalating the complaint to the board? Well, this now is obviously a response to Andy's concern that was raised. Andy, if you want to respond, he says, the employees have approached CCMA complaining about the conduct of some sheriffs. Is it possible for sheriffs to provide employees with their contact details? Should the applicant, CCMA or the CCMA, wish to obtain clarity in regards to the complaints before escalating to the board? Basically, the gentleman is asking for contact details of the sheriffs over and above his employees, so that the CCMA and the applicant can communicate directly with the sheriff before going to the board. Andy, you want to respond?
I think that the South African Board for Sheriffs will be able to provide the CCMA with the list and contact numbers of all the sheriffs countrywide, and obviously circulate to all the CCMA office provisionally, and they will have the contact details of the sheriffs countrywide. So I think that is where the starting point should be.
Okay, thank you. Thank you very much, Andy. Colleagues, we are about reaching the conclusion of our workshop, but before I call on other participants, I want to bring in the chairperson of SABFS, June Thomas, and the president of SAS, Petro Root, and the executive manager of the board. What I would like to do is in order to assure the CCMA that the profession obviously is serious about service delivery and more importantly, resolving issues raised by the CCMA in regards to the sheriff's performance in terms of executing this enforcement awards. I want to go through the Mr. Manchula's presentation, which right at the end called areas of improvement. And I noted there's a few aspects that he raised in the areas of improvement that relates to sheriffs and how we can directly impact on improving service delivery from our end. So June Thomas and Petra Ruth, if you're online, if you can assist me in responding to these aspects. In areas of improvement, Mr. Manchula says that advertising, lack of resources on our part, preferable that sheriffs cover this and the CCMA pays. Just some assurances or just some suggestions, if you can assist me in assuring CCMA that we will look into these matters. Is basically CCMA wants to know whether the sheriffs are willing to assist in drawing up the advertising and the sales notices. Mrs. Root, you want to come in?
On that aspect, I believe that most sheriffs already assist the applicants in this regard. The problem is when it comes to advertisements. The advertising costs could be a problem, but with the drawing of the notice of sale, I think there is assistance from the sheriff side in most instances. Thank you.
Okay. The other, while you're online, CCMA is calling upon the associations and the board to encourage sheriffs to open accounts for the respective sheriff CCMA officers. Do you want to respond? And let me give you one more. Improved communication between the sheriffs and CCMA. Basically, Mrs. Root, what I'm trying to do is trying to see how your association can assist the CCMA in regards to these issues.
Thank you. What was the third one? The third issue?
The second one is opening of accounts for the CCMA. Yes. How does your association, how can your association assist? The third one is improved communication between the sheriffs and the CCMA.
Thank you. As far as the opening of accounts is concerned, I believe that most sheriffs do open accounts for the CCMA, and we are in constant contact with our members, and they do communicate when there's issues in relation to payment, delayed payments, and so on. And I quickly checked, and we do have a list of all the regional offices. We do have that, and we will circulate that again to our members. We certainly encourage members to open accounts for the CCMA offices. We can just maybe clarify in terms of different offices. Say if the sheriff in Pretoria receives instruction from the CCMA in Cape Town, what is the procedure there? Do we open a second account then for Western Cape CCMA office? In terms of the improved communication with CCMA, I want to thank the board for facilitating this workshop and putting us in a direct contact line with the CCMA. I think this will go a long way to ensure we can resolve issues, we can pose questions, and we can get direct information from CCMA management. Thank you.
Okay, thank you. Thank you, Mrs. Root. I don't know whether Mrs. June Thomas is online. Ms. Thomas, I'm looking at the areas of improvement. CCMA say clear requests for instructions from sheriffs and quick responses to be given to the CCMA. How can your organization assist the CCMA? If there's any suggestions from your part. Thank you, Mrs. Root. You can put your camera off. Then the next question is, or the next suggestion is, sheriffs encouraged to strive to recover their costs from the sale. And when parties decide to settle this, your CCMA as a last resort. How can you assist the CCMA in encouraging your members to do that? And the third one is sheriffs to assist with explaining the process to employees where goods have been hidden after attachment. Ms. Thomas, do you want to come in? Oh, I see Ms. Thomas is offline. Mr. Burton, if you want to come in as the Deputy Chair of the organization.
Just a few things that in terms of communication, I think it's very important that the sheriffs, especially let's use Gauteng for example, have the direct contact details for the various offices they serve, or who they attend services for example, Benoni, Pretoria, or whatever the situation, just so that they have a direct line. I think it's also very important just to raise a point that I heard somebody, there was mention made of settlement agreements. It's very important that when the settlement agreements are being negotiated between the applicant and the respondent, where the CCMA is involved, the sheriff must become part of that negotiation. Because once the settlement agreement is in place, and the sheriff was not part thereof, all the monies that have been negotiated is paid to the applicant via the respondent, and no sheriff's fees are paid. And then the CCMA needs to fork out removal costs, storage costs for goods that are currently in storage, but a settlement has already been arranged and or made, and those and the money's paid over. In terms of, there was another question. I'm sorry, I thought it was addressed to June. So just
you can proceed.
No. If you can just, there was a third question you posed. Can you just repeat that one?
The sheriffs to assist with explaining the process to employees where goods have been hidden after attachment.
I think that's also very important. Thanks, Alan. I think it's also a very important issue because when the individuals come to us with their requests, they literally think that the sheriff it's just a walk in the park. So I think it's very important that we must be in a position as sheriffs or as officers to at least give them a rundown of the procedures, if not in a pamphlet. I previously mentioned at least in a verbal manner so that they can understand it, especially in their own language, because we have language barriers in all these areas where there are 6 or 7 dialects spoken. And I think it's very important that a person can be addressed in his own language so that he understands the process and doesn't have any unreasonable expectations when it comes to the execution of his award.
Okay. Thank you, Mr. Burton. Another point I want to raise from the presentation of Mr. Manshule, which I believe is very important to the associations so that you can filter this information down to your members. He says that upon receipt of remittance, sheriffs should submit updated statements. Obviously, this would assist the CCMA in reconciling their books as quick as possible before your next month-end statement reaches them. So sheriffs are encouraged to ensure that they reconcile their payments on time and obviously effectively and correctly, so that payment process and management of the accounts can be done much more easier between the CCMA administrators and the sheriff's officers. That's one of the important points that the CCMA has raised in its presentation, which I felt organizations can assist in encouraging their members. Mr. Manshule, before I close, I don't see any further questions on the Q&A, but I just wanted to assure participants that this workshop is being recorded and further dialogue will take place in regards to any unanswered questions or concerns raised by sheriffs and CCMA officials. But I want to give an opportunity to Mr. Manshule and his colleagues that's online to round up this workshop.
Hi, Alan. I see Petro's got a hand up.
Oh, sorry, Petro. Sorry, I didn't see you there. You want to come in, Petro?
Yes, thank you, Alan. Just in conclusion, on the issue that Ian raised earlier on, and there was a response in terms of the cost. The sheriffs want to come in and assist with the service of the initial notice to the employers. Remember, we already raised this issue and Ian explained it. I just want to take that point a little bit further. is it not possible, or we want to make a proposition to put a trial to this thing, to involve sheriffs in this initial service, even if it's not a physical service with a service fee. Why not look at a possible email service, where there's a further confirmation by the sheriff that the document was served, and it's in the enhancement of this whole process, to get the employers to attend these hearings. Thank you, Alan.
Thank you, Mrs. Roth. Mr. Manchula, you want to respond and you want to round up your presentation?
Sorry, Alan, I see Ian also has his hand up.
Sorry, man. My screen has been blocked. Mr. Burton, you want to come in?
My apology. I know.
No, sorry, I got a different screen open, so I can't see your face. Sorry for that.
If I can just put in a suggestion here, I think it's very important that the CCMA are aware of the board's website, because they were talking about communication and contact details of sheriffs and how to get hold of the sheriff if the sheriff hasn't given the applicants his contact details, which I don't think ever happens, because they deliver the documents, so they receive something from the sheriff as proof that their documents were delivered. But I think for the CCMA as an organization, it is very important that they are aware of the search function for a sheriff on the SA Board for Sheriff's website, where they can either just put in the jurisdiction or the sheriff's surname if they know it, and they will receive all the contact details on the website that will assist them far better than expecting the applicant to provide them with telephone numbers, emails, whatever the situation may be. So I think that might be a better remedy than expecting the applicant to bring them contact details for the specific sheriff that needs to be contacted. Thank you very much.
Thank you for that, Mr. Burton. Thank you. Mr. Manchula, you want to come in?
Thank you. Perhaps I would ask Marius if he's still with us to do the closure for us, Marius.
Thank you, Khaleesi. Yeah, I think from our side, Alan, and to the colleagues from the Sheriff Boards and Associations, thank you very much for this invite, setting up this session. And I want to echo the sentiments to say that through these types of platforms, we help to iron out problems that we may be facing on a day-to-day basis. And those problems then eventually has a hindrance towards the people that both the sheriffs and ourselves want to assist. So thank you very much for this opportunity. Thank you for sharing. And I think going forward, we shouldn't be seeing this as a once-off. I think what we need to do is on a regular basis, keep contact with one another, because the law is dynamic. Things change. And unless we keep contact with one another on these types of platforms, we may find ourselves in another 4 years' time, having great impasses instead of being able to just chat about these matters and finding solutions and moving forward. So thank you very much for a fantastic session. Thank you.
Thank you, Mr. Marius. To further enhance this relationship between the CCMA and the sheriff's profession, we must call on the board to also keep abreast of the progress in this relationship and ensure effective communication between the two parties, and obviously to further enhance the relationship. So we'll call on the board to do that as well. I know the board has been very effective in ensuring that this workshop takes effect. On behalf of the South African Board for Sheriffs, chairperson of the board and board members, and the executive manager of the board, I want to take this opportunity to thank all the participants, both the organizations, SABFS and SANAPS, all senior commissioners and regional commissioners attending this workshop, and also Mr. Manchula for your continuous engagement and collaboration with the board and the organizations. I'm hoping that this session has assisted both parties in ironing out certain challenges that we face. I know that solutions might not come immediately out of this workshop, but we have a way forward. I found a few as a practicing sheriff, I found a few solutions to my problems as well regarding the enforcement awards. So I'm sure sheriffs have listened carefully to this process, and obviously going forward, we'll find further solutions. Jody, okay, Jody, you're online. You want to come in for a closing statement?
Thank you so much, Alan, and the rest of the participants today. I must say that the engagement has been very robust in terms of its approach, and I think as you indicated towards the end of the session, you indicated that that we will look and continue to build relations, which I think this was the first of a few engagements that we will be having, where we will actually look at what's come out of today's session, see what we need to pick up, and then have very focused sessions around the balance of the area. But I thought today's session was fantastic in terms of the engagement, in terms of the feedback, and the questions asked. So I wish from my side to just thank the participants for their engagement today. And like we said at the start, it is about engaging. It is about asking questions, and there was much that was asked and answered. A special thank you to everyone who has taken the time again to attend, including our board members, the chairperson of the board, Ms. Charmaine Mabuza, and then of course our moderator and all of the other participants. So thank you so much for your time.
Thank you, Jody. Thank you very much. Colleagues, to sheriffs, deputy sheriff staff, the association's management, we want to thank you as well for developing the documents that was presented today and affording us the opportunity to work with you and find solutions to all our concerns. Colleagues, before I close, I want to thank a very important party to this whole workshop, and that is Innovate, our communications specialist, Ash of Innovate Inc. Innovate Inc. is the name of the company that's assisting us with this Zoom or webinar meeting. Thank you, Ash, and your team for being there for us, the South African Board for Sheriffs. And most importantly is, colleagues, she's done this webinar free of charge for the profession. So we want to say a very, very big thank you to Ash for your professional assistance in ensuring that we meet our goals as the board and obviously engage with our stakeholders. Thank you and your team for that. Colleagues, with that said, I want to thank all participants, all senior commissioners and regional commissioners, and Mr. Manchula for your engagement. And we assure you that your concerns are our concerns, and we will definitely look into the concerns raised in your presentation and find solutions to them. Likewise, sheriffs and deputy sheriffs and admin staff, we will obviously look at your concerns as well. And through the consultative forum, hopefully the new board can take this up as a project and find solutions. Thank you so much, colleagues. I want to sign off now. Thank you very much for attending.